All right, Mr. Anderson, is there anything you wish to say before sentence is pronounced?
How much time do I got?
Well, I'm going to talk about that a little bit. Oh, you mean how much? Oh, I misunderstood. I've had people give a
Yeah,
slightly
we're not,
different version
not
of
that version. Yeah.
How much time do you have to talk?
Yeah.
Yeah, I'll give you a reasonable period. I mean, this is one of the major events of your life, so you're certainly welcome to speak. I'm not going to say it's unlimited, but you're welcome to tell me what you think. Speak from your heart.
I don't want to go into all the details of the case. I got a lot of dispute about what was said, what was portrayed. I think the facts, with a little more scrutiny, tell a much different story than what the jury decided. And I don't think that things played out fairly. I think that there's some things that are not just from our side, questions outstanding for both sides. And I don't think the court accomplished what it set out to do in any means if both sides are left with so many questions. And I don't think, without going into the case, I don't think we really got to the heart of the matter. What I can tell you is I didn't kill anybody. What I can tell you is I didn't stalk anybody. And what I can tell you is I didn't dispose of any corpse. It's really weird to be sentenced for or convicted for it and soon to be sentenced for it, but I didn't, Judge. It kind of feels like there's no turning around on that now. I don't really know how to make a better statement of my opposition. But I disagree. I'm innocent. I don't know what you're going to decide. I don't know what you're all going to weigh. I don't even know how to represent my own character without having my family be able to testify on my behalf. But they do have some things that are relevant. I mean, even during the trial, there was a gentleman who tried to come up and talk to me. I think there was a comment about how now everything has happened during the trial when he made that attempt. Nobody really knew who he was, and I do know who he is. He's a man who I saved from assault in jail. He's actually related to one of the jailers, and my heart went out to him because I know he appeared inebriated, and I know he struggles. And I know he was coming up here to talk to me because we got along so good. But those tiny little moments throughout somebody's life, nobody accounts for those. But what they do a really good job of is making up all of these things that they want you to believe when they can label you as a monster. I still didn't. It's still weird. I want to be remorseful, and I am for the things that I did wrong. You're welcome to sentence me for everything that I did wrong, just like the judge in South Dakota. The only thing that I disputed in that instance was whether or not I was coming back to Wisconsin with that, which the prosecution has now repeatedly made false statements about on their own assumptions, hoping that everybody in this courtroom, everybody that's watching this, would buy, oh yeah, he was bringing something back to Wisconsin. Not true. Was I caught with marijuana in my car? Yeah. Yeah, I was. Should I have? No. Had I been the rules there? Broke them. Broke the rules. And when they said, hey, this is a problem, I said, well, I did knowingly, and I'll be held accountable for it. That's it. And if I killed somebody, whatever that situation was, I can tell you in my own heart it wouldn't be intentional. But if I didn't at all, the guy I never met, I don't really know what this is, but I didn't do it. I'm innocent, Judge. Not guilty. I'm innocent. That's all.
Thank you. When I came out of law school and took my first job right here in Kenosha as an assistant district attorney, the statutory penalty for what the equivalent of this crime, murder of the first degree, was life imprisonment, as it is today. And before an individual was eligible for parole, 13 years plus, I think, 3 months, something like that, had to be served. And only at that time could the individual apply for a parole. And not a lot of people got paroled at that time. Over the next period of years, maybe within 10 years, the legislature had, as I recollect, and I think at the behest of the Department of Corrections, had reduced that minimum parole period to around 11 years. And they had it down to around 9 when the law started to change, and the legislature passed a law under the sponsorship of Senator Joseph Andrea from Kenosha that became known as the Life Means Life law, and it didn't provide exactly what it does now for absolute denial of eligibility for parole, but it did allow the judge to fix the minimum period to be served before a person convicted could be eligible for a parole. And then ultimately the legislature made further modifications to the point that the court now has the authority to deny eligibility for release altogether. It's interesting, the statutory penalty has never changed. Life imprisonment. But the eligibility for release has changed very dramatically. And of course, that means not that you get paroled, but you could apply for a release to extended supervision. The price for intentional homicide in this degree remains the same, life imprisonment. And every life is the same. These people have come here and expressed their very touching, moving sentiments about this person whom they loved. And that all is permitted for them to do because they're the victims and they've suffered a loss without any contribution on their part or that of Mr. Gutierrez. They've suffered a loss, which the jury has found, as was their power, to have been caused by you. So they're entitled not only to express and their mourning condition, but also to focus on what the text of the law actually says and ask that you be sentenced to life imprisonment. But the legislature, although it could do so, has never provided that life means life in those explicit terms, except in some cases where the judge cuts it off. And in a very high percentage of the cases, I do deny eligibility for extended supervision. But it's not every case, and every case has to be looked at separately, as your lawyer has pointed out. But like physicians at the hospital, when they have people brought in from a shooting incident, are not permitted to discriminate on the basis of age or sex or religion, or even maybe a police officer who's shot, and the guy who shot him. The physicians are trained and are ethically bound to treat people in order so as to preserve life. They're not allowed to treat the less seriously injured and let the, or excuse me, they're not allowed to treat the less seriously injured police officer before they treat the person who shot him. It's at the core of our beliefs about the value of human life. And it is expected, and it should be the same for judges. Every life is to be given the same degree of respect by the law. And when it is ended criminally, as has occurred in this case, every life that's lost should be valued the same. So when you read about these frightening statistics about the killing rate in some of our major cities, and unfortunately even here, the legislature still has not given us the command that every case's life means life. They've provided that a number of factors have to be considered. And those are what your lawyer referred to as the Galleon factors. One of them is not that you're a bad person. I'm not commenting at all on the type of person you are, because it's not part of the equation. What you did was frightening, horrible. And you can wag your head all you want. The jury found beyond a reasonable doubt that you did it. And so the loss of these people is beyond measure. But it is important that they realize that I have this litany of factors that I must consider, and that what ultimately is the sentence that you receive is not the measure of the value of Mr. Gutierrez's life. That's if the law is what it is, then, and the judge considers those factors and doesn't impose a life without parole sentence, the family, while I certainly don't expect them to agree with the outcome, should not take that as a comment by the law or by me or by the legislature or by the jury that Mr. Gutierrez's life wasn't as sacred as they believe it was. The Department of Corrections has a policy of the reduction of sentences. They've got, well, the best, clearest example I can think of is people who are convicted of seventh offense, driving under the influence, and who are required, I think, the law is minimum 3 years. I think that's still current. The judge was required by law to impose that sentence, minimum 3 years. The Department of Corrections was releasing people in big numbers after 7 months because they had come up with some treatment program that they thought was effective enough that 7 months would be an adequate period to serve. So they broke the law repeatedly and released people at 7 months until the Court of Appeal, a couple of judges from Milwaukee caught them on it, and the Court of Appeals put a stop to it. The current administration is committed to reducing the prison population by 50%. And there are more and more programs being pushed into the courts all the time to facilitate the reduction of our sentences. And I just heard about another one today that we're going to be a pilot project for, where the drug courts, which have been originally, we were told were going to be very selective about who got in and who got much more modest outcomes. Now Kenosha is going to be part of a pilot project, and as I understand it, every single offense is going to be reviewed for the drug court. So it's, without commenting further, I'll just say there is a very large effort being made to let people out of prison, or not let them in the first place. And why am I bringing this up now? It's because any sentence that I give you, well, not any sentence, but just about any sentence, is going to last long enough that you will be an old man before you would be considered, even if I do make you eligible for extended supervision. And the last thing the Department of Corrections seems to want is old people in prison, because they're expensive to care for them. There was a reference to the sentence that you deserve. And I understand why people would say that. And I can't say I don't say it myself when I see about some of these crimes that are portrayed on television. But I don't like to get involved with what people deserve. That's kind of a frightening concept to base a sentence system on. Actually, the reason we have the criminal justice system in the form we have it, where the sentence is imposed by someone who's neutral, is to reduce violence. Because if we didn't have this system, people would take it upon themselves to give people what they deserve. And I'm afraid in the era in which we live, with the way things are being handled in the criminal courts, we're going to see more and more incidents that'll be branded as vigilantism, which are merely reflective of what people will turn to when they don't feel justice is done through the courts. So that's a factor that has to be considered, is the sentence has to address the enormity of the crime. I was very, very moved by the testimony or the remarks today by the lives that were touched by your vicious criminal act. And I wondered, to what extent did this man even think about these things? Was he so wrapped up in himself that it didn't even matter to him the effect it would have on the people who loved him? So if I got into the issue of deserve, that would certainly be at the forefront. I will say that you have been cooperative throughout these proceedings. You did not contaminate this courtroom by giving perjured testimony, which a very large share of our offenders do. The degree of planning of the crime and the concealment is very concerning, and speak to long-term determination of lawless behavior. On the first count of the information, it is the sentence of the court that your custody be committed to the Department of Corrections for a period of 2 years, followed by a 2-year period of extended supervision. On the second count, for an identical sentence to be served consecutively. On the fourth count of the information, hiding a corpse, for a period of 6 years of initial confinement, followed by 5 years of extended supervision, to be served consecutively to counts 1 and 2. And on the third count of the information, it is the sentence of the court that your custody be committed to the Department of Corrections for confinement in the Wisconsin state prisons for the remainder of your life. This sentence is consecutive to and not concurrent with the sentences on the other 3 counts. The period of eligibility for extended supervision will not occur until 40 years following the date upon which you start the sentence on count 3. You have rights to appeal with respect to the disposition of this case, and your attorney will review them with you. If you understand your rights, tell Ms. Muller. She'll have you sign a document acknowledging that. If you don't understand, tell her. She'll bring you back in here for further instruction. There's a copy for you as well. Persons convicted of felony, as you have been, are ineligible to have firearms in their possession. That is a lifetime prohibition, and unless you have a permit from the Secretary of the Treasury, you may not have a firearm in your possession at any time for the duration of your life. It is a serious state and federal crime for you to do so. There is credit to be allowed for 1,092 days in custody to be applied to the sentence in the sequence 1, 2, 4, and 3. All sentences, as I think I indicated, are to be served consecutively to one another. The conditions of its extended supervision, I think I'm actually going to withhold any action on that, on the supposition that there will be no extended supervision until he's 95 or thereabouts. And they can best be addressed. Well,
They're going to ask. They're going to require.
you know what? I think you're right. Although I did do one and it didn't, and it hasn't come back yet. You'll abide by all rules and regulations established for you by your supervising agent, pay the costs and disbursements of this action, repay to the, well, that one, no. The matter of restitution is to be referred for examination by court commissioner and return to the court with recommendation within 60 days. You're not to have a firearm, I did that already. No contact with any member of the those who are statutory victims in this case, except as is allowed by your supervising agent. Any other conditions requested?
No, thank you.
Anything else?
Judge, as far as the, I just want clarification on the no contact with those considered to be victims. I know that OA has been categorized in that way in this case, and naturally, I guess the clarification that I want is that was the no contact that was just discussed had to deal with if the individual was released, that'd be a condition of the release. But while in custody, is there going to be a no contact order issued?
I'm not aware that I have the authority to issue any order on that.
And I would agree, Judge, I just wanted that to be clear on the record.
I'm not imposing any order on that. I think that's a determination to be made by the Department of Corrections. Do you disagree?
Well, Judge, I think you do have the ability to make that order because there is a crime for contact after conviction, violating a court order. But my understanding is OA is not requesting for a no contact.
I've had a chance to speak to her in court.
Okay,
She's not requesting that.
okay. I'll leave it as is then. Anything else?